So I received a cue, so I'd like to start officially. So thank you, everybody. Bonjour et bienvenue. Merci de vous joindre à nous. My name is Asami, for those who are new. I'm the Executive Director of the Japan Society, one of the co-hosts of the event today. Japan Society is a national, member-supported, nonprofit organization based here in Toronto. Our mission is to strengthen business ties between Canada and Japan by fostering dialogue, connection, and collaboration across sectors. The Japan Society est une organisation nationale à but non lucratif basée à Toronto, financée par ses membres et mandatée pour renforcer les liens commerciaux entre le Canada et le Japon. We respectfully acknowledge that the land we're meeting on this traditional territory of many Indigenous nations, including the Mississauga of the Credit, Anishinaabe, the Chwaluk, Haudenosaunee, and Wendat people, and it's now home to many diverse First Nations, Inuit, and Métis peoples. We also acknowledge that Toronto is covered by Treaty 13 with Mississauga of the Credit. Today's event is a resultful or meaningful collaboration between Japan Society and our partners at Fasken. Thank you so much for Fasken team to partnering with us and for your throughout planning and support in bringing today's conversation to life. The topic today, Lunch and Learn, is one of the six that intersection of Indigenous partnership and energy sector in Canada and foreign investment, an increasingly important and complex space. I'd like to thank you, our speakers from Fasken, whose expertise in Indigenous and energy law will help us better understand Canada's implementation of Bill C-5, also called as One Canadian Economy, and the evolving opportunities and responsibilities that come with it. We are also pleased to welcome participants joining us virtually from across the country. Today's program is endorsed by several Japanese-related organizations in Canada, and I'd like to thank the following of the support and engagement: the Alberta Japan Business Association in Calgary, the National Association of Japanese Canadians, the Quebec Japan Business Forum, the Toronto Japanese Association of Commerce and Industry, known as Shokokai, the Vancouver Japanese Business Association of Commerce and Industry, known as Komakai. Thank you for your collaboration and for sharing this dialogue with your communities. Now it's my honor to introduce a special guest, Mr. Takeshi Matsunaga, Consul General of Japan in Toronto. He assumed his post in 2023. It brings him with a distinguished career in Japan's Ministry of Foreign Affairs. His leadership and diplomatic engagement continues to strengthen the relationship between Japan and Canada and Ontario, both in governmental and community contexts. We're grateful for his presence today. Please join me in welcoming Consul General Matsunaga for a few opening remarks. Thank you so much. This is the microphone.
Thank you, Asami-san. Thank you very much. Good afternoon. I'd like to thank Japan Society and Fasken, and it is my great honor to greet distinguished panelists today. Well, it is a great pleasure to greet everyone here and a lot of familiar faces. Well, the topic today is very important. While Canada's demand for total energy is projected to decrease by 2050, the extent of which, depending on its trajectory to net zero, its demand for electricity is projected to increase by 40 to 50% by 2050, driven by the electrification of transportation, industry, and data centers. Here in Ontario, according to the IESO, the province's electricity demand is projected to grow by as much as 70%, 75% by 2050, with industrial demand of which being equivalent to adding a city the size of Toronto to the grid. Externally, expectations for Canada's export for natural gas, transitional energy resources, as well as for hydrogen, clean burning energy carrier are high. For example, opening pathways to building new energy sector investment and related infrastructure. Arguably, the most important challenge of investment in Canada's energy sector would be building successful Indigenous partnership. In particular, Indigenous equity investment is in investments in energy and related infrastructure projects are key not only towards advancing economic reconciliation with Indigenous peoples, but also for managing project risks through efforts to align the stakeholders' interests and facilitating Indigenous support and consent for these projects. The number of Indigenous equity investment has increased significantly in recent years, as you know very well. The trend is likely to gain force further once access to affordable capital is unlocked. The federal government has already doubled its Indigenous loan guarantee program to $10 billion to help feed capital for Indigenous communities to gain full equity ownership in major nation-building projects. Ontario also provides resources and opportunities for Indigenous equity partnership, for example, through nearly $3.1 billion, including through tripling the total amount of loan guarantees through its Indigenous Opportunities Financing Program, formerly to $3 billion, now expanding eligibility, the scope of which beyond the electricity sector to include eligible projects in mining and critical minerals, resource development, energy, pipelines, and other sectors. The federal grant program that have allowed renewable projects to move forward with Indigenous partners also play an important role, obviously, especially in remote regions and in off-grid communities. In conjunction with strategic investment from the Canada Infrastructure Bank, they are expected to promote renewable energy projects in partnership with the Indigenous communities. The choice of how these Indigenous equity participations be structured is also a matter of importance. The choice will depend on the desired level of management control, financing, and various tax and tax credit considerations. Now that both the federal bill C-5, the Building Canada Act, and the Ontario's Bill 5 Protect Ontario by Unleashing Our Economy Act 2025 have received loyal assent, building genuine consultations and partnership with the Indigenous community be of utmost importance. The theme of today's seminar, therefore, is obviously highly opportune and valuable. This moves toward finding ways to remove regulatory barriers and expedite projects across the country aims to include Indigenous businesses. At the same time, as you are all aware, concerns are voiced with respect to the powers that these bills would allow governments if a relevant community was not in support of a project, for example. The investments and priorities of the Indigenous communities vary, and obviously early and genuine consultations will be warranted. Having said that, a chance for Indigenous businesses to be a part of project development and to be equity partners would help. I guess. The trust needs to be built to develop meaningful partnership. Doing so in the current urgency to get energy projects off the ground would be a big challenge. Therefore, I hope today's seminar will inform us of the current situation and future prospects, guiding us towards equitable, sustainable, and hopefully speedy materialization of potential new investment in energy sector for the benefit of the country. I also hope Japanese public and private sectors can play meaningful roles as their Canada's trusted partners. Thank you very much.
Thank you very much for that, Mr. Matsunaga. Hello. Now I would like to pass the microphone to Ms. Nicole Park, partner at Fasken, a distinguished lawyer and strong supporter of Canada-Japan business relations, who has worked closely with many of Japanese companies who are here today. Thank you, Nicole. Please to the podium. Thank you for having us today. Arigato.
Again, arigato, Sami-san, for the kind words. Arigato, Consul General San, for joining us today. Konnichiwa, good afternoon. Thank you for joining us here at Fasken's Toronto office on this beautiful day. We're here for a lunch and learn, investing in Canada's energy sector, Indigenous partnerships, and Bill C-5. We're thrilled to have you join us for what promises to be a dynamic and insightful panel discussion. As Canada moves forward with the implementation of Bill C-5, the energy sector is undergoing significant transformation, particularly in the realm of Indigenous partnerships and equity participation. I will let our moderator and panel dive deeper into the content to be covered today. Speaking of which, we have a distinguished panel with us. And leading discussion is Fasken partner Myroslav Chwaluk. Myroslav is a corporate finance and M&A lawyer who provides strategic, pragmatic advice to participants in the capital markets across industries. He has particular expertise in the natural resource sector as it relates to mining and has advised on complex financing matters, acquisitions, JVs, and streaming and royalty transactions. His curious and thoughtful approach make him an ideal moderator for today's discussion. Thank you again for being here. Without further ado, I pass it over to my partner, Myroslav.
Thank you so much. Thank you so much, Consul General Matsunaga-san, Sami-san, and Nicole for your warm remarks. We're honored to welcome our distinguished guests from the Japan Society and elsewhere here today for what we're confident will be an enlightening discussion, not just for yourself, but for me as well, because I'm learning about the Building Canada Act in real time in my practice as well, and following developments very closely. So a very warm welcome to everyone here and those listening to our discussion online from Fasken. So who is Fasken? We're an international law firm with offices across Canada and London and Johannesburg, with, among other skills, deep expertise in resource project development and Indigenous participation in project development, including with the Chamber's Band 1 ranking in Aboriginal law. And so to discuss our topics here today, we've assembled a panel of subject matter experts from across the firm, who I have the great pleasure of introducing to you now, starting with Zach Romano, a lawyer from our Vancouver office, who advises clients across Canada on a wide range of Indigenous and project development matters, including consultation, negotiation, and the regulatory process. A significant portion of his practice involves negotiating and drafting impact benefit agreements and Indigenous equity participation arrangements in respect to major projects. And he has significant expertise in advising on strategic aspects of development, permitting, and construction of projects within traditional territories. Zach is Métis from Treaty 6 territory in Alberta and a citizen of the Métis Nation, and regularly lectures and presents on Indigenous development issues. And being on the West Coast, Zach sacrificed a lot of very early mornings for us preparing for this presentation. So we are very grateful to have you with us in Toronto again, Zach. Thank you. Our second panelist is Chelsea Young, a lawyer in our Toronto office with a broad corporate and capital markets practice, and as well as a specialized practice in Indigenous legal matters, who I'm very glad to have the opportunity to work with often. In Chelsea's work, she advises natural resource and energy companies and Indigenous communities on equity participation models, economic partnerships, and Indigenous-led development projects. Chelsea is Inuk on her mother's side and grew up in Nunavut and the Northwest Territories. So she brings firsthand cultural knowledge and a deep understanding of Indigenous perspectives to her practice, bridging industry and Indigenous communities with a culturally informed legal practice. And rounding our panel is my partner Ian Palm, a lawyer in our Toronto office with a broad corporate practice, who frequently lectures and presents on topics including those related to the energy development sector. He's a frequent lecturer on private equity, M&A, and securities law, and is recognized as a leading lawyer by many organizations. And his understanding of the investment landscape and regulatory environment makes him an essential resource for those looking to capitalize on opportunities in the Canadian market. So, to set the stage, our discussion today is targeted at what we believe are, like myself, non-experts in Indigenous participation in major project developments in Canada. So I'm hoping not underselling any of our audience members here with that assumption, but unfortunately, I feel like despite a number of successful and innovative development partnerships across Canada, non-expert experiences with Indigenous participation in resource development projects is limited to a headline understanding of just general opposition to such projects. But that's obviously a very narrow understanding of what's going on and missing a complicated history between Indigenous groups and the landscape of participation in such projects in Canada, both historically and currently. So before we go into a detailed discussion of actual participation and partnership models, perhaps Zach, you could set the stage for us today by helping us understand who are we talking about when we talk about Indigenous peoples in Canada and their rights, roles, and participation in these kind of projects.
Thanks very much, Mo. So just to begin us today, let's see if my clicker works. It does. We'll try and cover about 300 years in 10 minutes or less, and Mo will cut me off if we go too far down the rabbit hole. But in seriousness, when you're in this area, it's really important to take stock and truly understand the context for Canada today, and it starts in the early 1700s. Our highest law in Canada is the Constitution Act, and it has a provision within that act which protects Indigenous rights for three categories of Indigenous peoples: First Nations, Métis, and Inuit. Now, this is really important because these communities exist across Canada, but in different locations. We have First Nations, and for those in the room who know all this already, I apologize for the detail, but just want to be sure we're coming to the right level of understanding to begin. But we have about over 600 First Nations communities in Canada, spread, if you think about, throughout Canada, coast to coast, from east to west, and predominantly in the southern part of Canada. There are some First Nations in northern Canada as well. We then have, and those are the first people, we then have the Inuit, the people of the north. Those people coming in the Arctic since time immemorial. You then have the Métis, who emerged as an outgrowth of the fur trade, later on through relationships between certain Indigenous peoples and certain European traders, and communities grew out of those relationships. So the rights of those three distinct groups of and categories of Indigenous peoples are protected by our highest law in the land. Why do you care? Why should you care? The reason is that it can create risk, but it can also create opportunities for alignment, which we'll hopefully get into today. Now, I promised you a bit of a history lesson, so I'll take you back to 1720, and I won't stay there long. But in 1720s, you start to see negotiations happening between then the British Crown and communities in the eastern parts of Canada. What results from those discussions, and apologies, I'm going to blame the federal government on the maps because these are the best maps they can give us of these treaties in one spot, but it gives you a sense of how we're looking here. You look on the far right of that map, there's the peace and friendship treaties, and those are the first instances of treaty documents that set out the rights and obligations of the Crown and the First Nations people in that area. What happened subsequent to that is you may have heard of the Royal Proclamation. Why is that important? Well, it set out a Crown policy that First Nations could only cede their land to the Crown. It couldn't cede it to private landowners. And that was a protective mechanism that did two things: recognize that title existed and set a policy for how development could occur in this part of the world. Now, I could go into a bunch of detail here, which I won't, but you then think 1763, there's a crown policy. This is quite a ways before Canada became a country in 1867, but there's treaties being negotiated essentially east to west. When Canada becomes a country, in the formation of Canada as a country in 1867, you then have a period of time where, frankly, there was rights denial. That recognition initially of title, the recognition initially of rights was denied for a number of years, and in many ways resulted in laws that marginalized Indigenous peoples, removed them from their land base, dispossessed them of their culture, dispossessed them of their rights to make decisions about their lands. And that's really important context, because when you're dealing with First Nation governments or Métis governments or Inuit governments, that history is lived. It's within the living memory of communities that are now opposite you on a deal today. We then move into, let's get into the later part of the historic period, we'll call it, up until about 1920. You have these historic treaties being negotiated I got into. Well, those treaties set out rights and obligations of the Crown, rights and obligations of the Indigenous people, and it essentially protected certain areas of land and certain types of uses of that land constitutionally. We then move forward into the 70s. So again, 50 years passed and we didn't have a treaty policy. This map shows you today where the treaties are being negotiated. And you can see the overlap, right? The middle part of the country, those are where the historic treaties are. These parts that are shaded now are where treaties are being negotiated. That's important because that tells you there are still parts of Canada where those rights that are protected in the Constitution have not been dealt with at all yet. They may have been proven through a court case. They may have been set out in a treaty. These treaties may overlap Indigenous peoples. There may be more than one Indigenous people in an area holding a broad constellation of rights and claims. And when you're thinking about building a project in Canada, you have to take all of this into account. It's very complicated. And so when you think of this map, what's important to take away is kind of three things. Rights are protected. The groups that hold the rights have a history and continue to use these areas in a variety of ways which need to be taken into account when you're developing a project. And as a project developer, if you get it wrong, you can hold a lot of risk. And the Crown, if it gets it wrong when it comes to dealing with these rights and claims, it can hold a lot of risk. So, yeah.
Well, I was gonna say, I mean, that there's so much we can go into over this, and I think that sets us up really well for the next part of our discussion. We can talk about this after, you know, like, where the rights come from. But 300 years is a lot to cover right now. So I think that setup is really good context. You know, let's talk about, bring it forward a little bit in our current project development landscape. You know, our development landscape is changing to some degree because we have this history, but we have a lot of global factors impacting our development landscape, including, you know, an inward-looking and volatile trading partner to the south that we were typically dependent on, trend towards internalization of supply chains, shifts to cleaner energy, and flight to energy security countries from reliable sources. So we see that played out in the interest in furthering Japanese and Canadian energy ties. I mean, it's a perfect example. So, you know, we're generally viewed as a stable rule of law nation. So the Building Canada Act is of interest to anyone involved in developing projects currently. So maybe we can just switch gears here and say, Ian, can you give us a sort of an overview of the Building Canada Act itself and what it entails and its impact on projects in the sector?
Sure. Thanks, Mo, and thanks, Zach. So Zach was talking about 350 years, which was ambitious. I'm going to try and focus on 3.5 months. And why it's important. So we've seen a significant amount of activity in a very short period of time, and Council General had some very good points that we're going to try and illuminate some detail on as part of this conversation. So the Building Canada Act came into force on June 26th of this year. It's part of a larger piece of legislation. The other piece relates to the reduction of internal trade barriers. But the Building Canada Act was implemented by the new federal government shortly after the spring election, and it's part of the government's response to a U.S. administration, as Mo mentioned, which is turned inwardly and is focused on imposing tariffs on rivals as well as close allies like Canada and Japan. So Canada sits at a crossroads, and there's four key considerations here. I think one is, candidly, our economy is suffering with significant productivity challenges. As we compare ourselves to other advanced nations, in particular the U.S. With new tariffs imposed by the U.S. on key sectors like steel and aluminum and automobiles and softwood lumber, and threats of others, Canada is now looking to reduce its reliance on the United States and seek to expand its existing markets and open up new markets. So in particular, with like-minded countries in Asia, in Europe, and Latin America. The third consideration that's important in the context of the Building Canada Act is governments at all levels in Canada continue to pursue a wide range of projects focused on reducing and, where possible, decarbonizing our economy. So I think the government has been clear that we're not turning our back on decarbonizing or climate change. That's still a very key component to actions going forward. And then the fourth consideration is something that both the Council General mentioned and Mo alluded to, and that is the significant challenges to meeting the moment for Canada is really about addressing the patchwork of overlapping and sometimes conflicting processes about getting projects approved, advanced from a development stage and an idea stage to construction on a timely basis. So the Building Canada Act is a response to these concerns, all of them. It ambitiously seeks to address them in a range of ways. So the purpose of the Act, and I want to get this in a bit of detail, is to advance these projects through an accelerated process that advances regulatory certainty and investor confidence. Okay, so regulatory certainty and investor confidence, while at the same time protecting the environment and respecting the rights of Indigenous peoples. So that's a challenge. So the way the Act is intended to address this is, and Mo cut me off when I
You're close.
keep going on. So what the government has done is it's established this concept of national interest and said projects of national interest that meet these certain thresholds, and national interest can include a range of things, but in the energy sector, it's pipelines, it's transmission facilities, it's energy generation, all of them would constitute national interest. And then it's assessing through a variety of criteria whether or not those projects of national interest get on a list. And once they're on a list, then they can be brought through an accelerated process so that certain decisions can be made up front with a set of conditions and with the government's stated goal, and it's right in the legislation, to reduce the project development process from 4, 5 or more years down to a maximum of 2 years, all at the same time respecting environmental protection and commitments to Indigenous rights.
Okay, I think that's a perfect lead in to what this group is probably interested in today, which is the interaction between Canada's Indigenous groups and the tension between government duties with respect to conservation and participation and the intended fast-track approvals. Government commentary on the Act includes wording such as commitments to building lasting prosperity, new economic opportunities with Indigenous peoples, while working to ensure respect and participation for a brighter future. But I think the biggest headline response, myself, what I've seen from headlines that I've read is just urging like sort of a slowdown and potentially some unsureness, lack of surety with respect to what the government is doing. So I think, Chelsea, maybe you're in a good position to help us understand how are Indigenous communities actually responding to this legislation and what impacts this might have.
Yeah, thanks, Mo. So there's been a bit of a mixed response. There's been concern. Some have responded with strategic engagement, and other communities have responded just with outright opposition to the Building Canada Act. And the core issue seems to be that a lot of Indigenous leaders feel that this bill, or this now act, is eroding their rights to consultation and their rights to consent. So when we talk about fast tracking a process, it's hard to see how that fits into a lot of their internal approval and governance processes. So for a lot of communities, they would need to take a decision back to a community assembly. They would need to engage in elder consultation, and they would need to conduct a lot of technical review. So That said, responses have varied significantly between the communities. So some communities with established modern treaties, like Zach touched on, they have strong governance frameworks already. So they are finding ways to work within this new Building Canada Act framework by engaging in or implementing impact benefit agreements early, and also arguing for robust consultation processes despite this legislative reform. Other communities, particularly those without settled land claims, they feel that the reforms give them less leverage. So you're dealing with two groups essentially in terms of the response. What impact will this have on major projects? I mean, you will expect to see increase in legal challenges, sometimes outright on the ground opposition that could look like blockades. Communities have made it very clear from the outset that legislative speed does not equal social license. And the paradox that actually is coming from this Building Canada Act is that although it might accelerate regulatory approval, you cannot accelerate or fast track trust or support from Indigenous communities. So it is a fine balance about what it's actually going to accelerate in the long run.
Thanks, Chelsea. That introduces a lot of potential issues for developers to deal with. We've seen a lot of different models and attempts at Indigenous engagement over time and developments over time as Canadians have become more attuned to these historical issues that we have and the need for economic reconciliation. And I think it's arguable that one of the most transformative shifts we've seen is the rise of Indigenous equity participation in major projects. Particularly, we're seeing a lot of them in LNG projects right now. It's being increasingly recognized as not just a tool for economic reconciliation, but also a strategic de-risking mechanism, aligning interests between Indigenous nations and industry. So Zach, you've been at the leading edge of this development and negotiating these kind of partnerships. For our audience, from your perspective, what's driving this momentum towards Indigenous equity participation in major projects?
Well, thanks, Mo. So just to build on the great points Ian and Chelsea made regarding the macroeconomic factors pushing us towards where we're going, the context for decision-making and rights held by nations who are impacted by these projects. It's important to look at this, I think, from the perspective of where we've come from and where we're going to. Where we've come from historically has been Indigenous was a risk. And these types of deals were done to mitigate risk. The risk arises because when you need a major project approval, the Crown has a duty to consult. And when the Crown consults improperly or not enough or not at all, as an owner or an investor, you are then at risk that nations could challenge those approvals. So what was happening at the beginning of, in the 90s predominantly and thereafter, was we saw equity as part of an IBA, an impact benefit agreement, where the consent from the nation for rights would be given in exchange for a myriad of benefits and commitments, including potentially equity. What's shifted now is we've got governments not at the table denying rights. They're in fact promoting consensus seeking. They're formalizing frameworks at law that are embedding those rights to participation with respect to Indigenous project participation, which is material because then, again, in that context of consent in exchange for certainty of rights and title, that equity becomes a really important benefit to be discussing. We're also in an area where nations expect consent to be sought. They expect that in some cases, equity is the highest form of evidence for that consent. So when you're thinking about impactful projects, mines, transmission lines, there's that context, but additionally, there's also types of arrangements that exist outside of these major projects, which are important, I think, to touch on briefly. Supply chain opportunities that may not touch on rights and title. We're seeing so much growth with respect to the mining supply chain, for example. Transportation companies have joint ventures with Indigenous peoples where equity is just a good business decision. It gets nations and their members who are impacted by projects participating economically in the benefits of a project, which is risk mitigative to you as an investor, to you as a project owner, and at the same time embeds that consensus seeking framework in a material way. And maybe just one other point to keep in mind, what we're seeing is in this context as well, what are these drivers? There's the institutional aspect, ESG, putting focus on good projects and bad ones, for example. Lenders looking at what a project needs to evidence to be in a position where it's not a risky investment. That consent and that equity is evidence of that. that type of a relationship, which is important. But it's important to think of the nations now ultimately wearing three hats. They could be simultaneously an owner, an equity owner of a project. At the same time, they could be a government who has obligations and rights to their constituents. And additionally, they could be a regulator of your project in a context like we're talking about with C-5 and the Building Canada Act. Thinking about it in that context, the multiple hats effectively that nations are wearing when they're across the table from you is really important for thinking what's driving equity as a model for facilitating alignment in these scenarios where you've got a major project where there could be rights and titles to take into account.
So you set out a number of different ways bands and proponents are approaching it. Ian, are you seeing any sort of trends towards one type or another? You know, Zach touched on a number of different models.
Well, so Zach's coming at it from the perspective of where First Nations are at, and where their thinking is, and I think that's really important. Like we're not trying to sugarcoat any of this. There are challenging negotiations to be had throughout these processes. I come at it from the perspective of I've worked in capital markets and M&A and financing projects for decades, and looking at it from the perspective of the investors into those communities, and historically looking at it as that was a risk. Now it's more about building partnerships, and I think it's useful. Can someone advance to the next slide there? So this, I mean, it's a little hard to see, but it's on the website of the Major Projects Office. So the Major Projects Office was the organization established by the federal government to manage this new regime that's being established. And at this stage, we've got a new CEO of that, Don Farrell, who's got decades of experience, including most recently in shepherding through the Trans Mountain Pipeline to expansion to fruition. And she's now been hired as the new CEO of the Major Projects Office. And in August, the Major Projects Office announced the first 5 projects, and 2 of which are energy projects. I raised this to sort of talk about the trends as you suggest, Mo. I think so. What can proponents do? What proponents of these projects do in engaging on this? So the first 5 projects announced are projects that are already well established. They've advanced to some degree with regards to regulatory approvals. They've advanced with engagement with Indigenous communities. What the Major Projects Office is going to do, was instructed to do, is reduce the timeline to get these projects completed, and also to assist in raising private capital and de-risk these projects to a degree so the structure works. Okay, why is that relevant now? And why is that relevant to other projects that the Major Project Office may continue to pursue? Because there's a number of tools that governments need to put into play and that private sector needs to put into play to make these successful to engage with First Nations. So I think one of the key trends, and I'll try and keep it relatively brief and just focus on the first trend, is government capital and financial security. So the Consul General mentioned the Canada Indigenous Loan Guarantee Program, and so a recent example. So if you look at the map and you look at British Columbia, there is British Columbia is a large country, country. So it's one of our largest provinces. In July this year, Enbridge, which has a gas distribution pipeline system throughout British Columbia, from the northeast in Alberta all the way down through to the U.S. border in the southwest, it sold 12.5% of its gas distribution pipeline system to an Indigenous group comprised of more than 38 First Nations. And why is that relevant? Well, that transaction could not have happened in all reality without the support of the Indigenous Loan Guarantee Program. So, that was a $750 million transaction. As part of that transaction, there's a $400 million loan guarantee from CDEV's new guarantee program. As part of the Building Canada Act, which came into force, we've increased the size of that program from $5 billion to $10 billion. So that facilitates the possibility of financing structures which are familiar to the private sector, which are familiar to domestic and international banks, so that we can put together Indigenous communities that understand the needs of the local communities and foreign and domestic investors, which understand how those projects can get completed.
That's perfect. That's a perfect takeaway. Thank you. That's really enlightening. So we've talked about reasons for these types of Indigenous equity participation models. We talked about trends in them. But we actually have lawyers here who are involved in making these work and have advised extensively on the strategic aspects of these. So let's get specific. When it comes to structuring equity participation, could each of our panelists speak to, let's say, one key term of common issue that arise with Indigenous counterparties? I say one just because there's some really interesting things I want to make sure we get to in the second part of our program. So, Zach, you want to talk about your points?
Sure. Okay, so at the outset, biased because I'm the person talking about governance, but I think governance is the most important, and for a number of reasons, I'll try and convince you of why that's the case. But when we think about governance in these types of transactions, really important to approach it from the perspective that this is not a typical M&A deal. There are nuanced reasons why you're at the table. There are the reasons that Ian and Chelsea have laid out. Financing needs to look a certain way, and all that needs to be taken into account. But when you think about governance and what that means, helpful to think about it in terms of two timeframes, because they're very important. At the outset, the first timeframe being the point at which you start your project, you start discussing the design, to the point at which the nations acquire their equity interest in the project. The second timeframe to keep in mind is the point at which the nations acquire until the life of the project is done. So in that first timeframe, governance, how are decisions made about the project from the point at which you've started to talk about it with the nations to the point at which they acquire their equity? There's multiple models, but there's essentially two variations that are really helpful to keep in mind. And if you can get nations to go to the first one, that's where you want to be. The model is essentially trying to get in a situation where you've got multiple nations who may be opposite you on a deal, acquiring an equity interest in a project, like a linear project, where there's inevitably multiple First Nations that could be involved as equity owners. Can you find a way to aggregate those nations into an entity, whether that's a limited partnership or a corporation or a not-for-profit, something that can then be the point of contact for you to negotiate the equity deal, as well as consult about the rights? If you can get there, that's from experience, the ideal place to be. The other variation of that, just for the example, say you have 5 nations, is that nations may tell you, you know what, we're not going to come together. We're going to deal with the company or the owner one-on-one. And that's challenging because you have to develop the trust that Chelsea was talking about in the context of multilateral negotiations with effectively 5 tables. How do you do that? That's complicated. And we do it on linear projects all the time. But the magic is to try and figure out, how do you create that trust? How do you bring the groups together with the right advisors? You can be advancing where you need to be on the regulatory side of these projects, embedding those rights to participate meaningfully in the regulatory processes, including things like Building Canada Act and those types of processes, environmental assessments, but additionally advancing that equity negotiation at the right speed and time so the nations can be in a position to know, I've done the diligence on the project, I can make a decision to become an owner based on what I've done so far. The other, just to touch on it, the other key piece to think about is, okay, the nations have become the owner in the project, they've acquired their equity interest, whether it's individually or as part of a consortium, but thinking about what does governance look like in that context. The most typical structure we see is essentially a limited partnership, and there's tax reasons for that. Nations can be tax efficient, and the way that rights look, whether as a limited partner in a limited partnership or as a shareholder and the general partner, if that's the type of structure you've got, may seem a bit odd, frankly, from what you may be used to in a commercial transaction where Indigenous owners are not involved. Minority protections look sometimes a lot different, more protective to nations. Thinking about how to structure that is really important from the outset to make sure that you understand what the structure needs to reflect in order to embed that trust, but at the same time facilitate the decision-making that can be predictable over the life of the project once you've got an owner on projects that we're talking about today. Like, for example, Cedar LNG, one of the projects on Bill C-5's list. The Haisla, the most impacted nation, are a 50% owner in that project. That's complicated. They got through it. They figured it out. There's projects that we'll go into later about that have similar success, but thinking through how to structure that from the outset is really one of the most important pieces to get.
Chelsea, one common term or key term you're seeing in participation agreements?
Yeah, so I think the thing that comes up the most is related to capacity development and capacity funding. So the three things that we typically see First Nations leaders arguing for or asking for in acquisition and governance documents surround first, training opportunities for their Indigenous employees. So that's not necessarily just an employment opportunity, but actually providing training so that these community members can develop the skills that they need that can then be transferred over to a different project. So they're not project specific. They could be just general management skills, administrative skills, just things that are generally related to project implementation. Second is intercultural training for non-Indigenous project staff. So when Indigenous employees are working on a project, they want to feel that they're being respected, that they're being heard, that the non-Indigenous employees understand what their cultural protocols are. And third is integrating these Indigenous protocols actually into the governance and management framework of the project. So whether that's how you conduct your meetings, whether that's how decisions are made, or whether that's how the project engages with the territory. Then so that's about capacity development. When we talk about capacity funding, that looks a little bit different. So you're wanting to provide funding in a way that allows a community to grow their knowledge. So some communities, they are going to have decades of business experience. They may have access to capital resources, so this becomes less important. But other communities, they are currently on their economic development journey and they don't have access to these resources. So the purpose of capacity funding is to help fill that gap. Where can we help build on their expertise? Where can we help build their internal capacity? And ultimately, what you're hoping for with this capacity funding is that you're going to make the projects more efficient and they're going to be more predictable. Because if there's a gap in knowledge, it's hard to predict what decisions are going to be made by the community. But if they have advisors that are independent, that are being paid for, those advisors will help get them to the place where they need to be to help expedite a project, or at least have everybody on the same page of where a project needs to go.
Governance and control, capacity development. Ian?
So I'm gonna come out from the other end of the spectrum here. I'm always trying to be a bit different. It's kind of hard, but yeah, it's a lame attempt at a joke. So front end of the projects, like Chelsea talks about capacity building, get these communities to a state where they can be engaged. I'm thinking about it from the standpoint of exit. So these are projects which are put on the table because a group of people think that they can make a decent economic return from it, or that they're going to kick off cash over time, and they're going to generate dividends. So an important consideration that you need to think about in building partnerships with Indigenous communities is really about on the finance side. So these are going to be your partners. Okay, so what considerations are at play for the need to put in new capital down the road? So and these communities will need to consider how and whether they're going to put those monies in. So there's basically three options that we see in projects. One is there's no need for additional capital contributions into the future, and these communities need to understand that and what are the risks associated with that one. The second one is really about if there is the need for additional capital, there's often a negotiation around deferring of that contribution, because a lot of cases these nations do not have access to a significant amount of capital, and so some of the negotiation will be around deferring that to some point in time, like commercial operation date or some date after the commercial operation date, so that they can get additional funding to make that additional capital contribution. And then the third, which is the most sort of straightforward you'd be familiar with, would be just pro rata sharing. So if the project requires some additional capital and it requires third-party capital in addition to the operating funding, if you don't make the contribution, you can potentially get diluted. And so we see projects of a variety of sorts, just like you would expect with a broad, diverse country with a broad, diverse collection of Indigenous groups.
That's a great place to leave it. So no one wants to invest in a project that is risky and doesn't have a chance of success. There's successful models of this happening. And I think it's important for this group to sort of understand how we get success and see an example of a successful outcome. So Chelsea, I think this is really a good time to get into it. Are you able to walk us through a successful Indigenous equity participation transaction you've been part of, and what were the factors that made it work?
Yeah, happy to. So an example that immediately comes to mind is our work with Hydro One. So we have been advising them on their Indigenous equity partnership model. And essentially what this is they provide a 50% equity stake in all future transmission projects that may impact their territory. So currently, these projects are valued in excess of $100 million. There are 6 transmission lines, 6 transmission projects currently on Ontario, 5 in Southwest Ontario, and 1 in Northwest Ontario. And essentially, any impacted First Nations, they have the option to invest in the limited partnership that will ultimately own the project. So when I think about what makes this work, I think about 4 key elements. The first is early engagement. So you're not going to these communities, talking to them after the project has already been developed, financed, and there's already a plan in place. You need to go and engage communities during project development. So this allows for meaningful input in terms of routing, environmental considerations, or generally anything else that the community might be concerned about, so that they feel like they actually are a stakeholder from the outset. Second is regulatory alignment. So in Ontario, the regulator is very supportive of Indigenous equity participation. They recognize that it's part of the broader reconciliation framework, and ultimately they see it as a way to improve project outcomes and help minimize some of the risk. Also, getting regulatory buy-in from the outset, it allows the Indigenous equity participation part to be built into rate base. So automatically it just makes things smoother from the get-go. Third is something I already touched on, which was capacity support. So we talk about capacity support not being a one-size-fits-all model. You need to evaluate it based on what a community actually needs. So you can try and figure this out on your own, but oftentimes it's just best to ask. So they may need financial or legal advice. They may need technical expertise. They may need help building on their internal governance processes. The ultimate thing is never looking at it as a one-size-fits-all approach and always trying to tailor it to the individual community. And the fourth and final piece is something that Zach had touched on about these projects being linear. So they aren't just going through one territory, like a mine, for example, where it may just impact one particular community. In this context, you are having a line that runs through multiple territories. So you need to have a very coordinated approach where you are working with multiple groups simultaneously. And where it becomes particularly complicated is where you are dealing with communities that may not historically like each other or may not currently like each other. So having to navigate these relationships where you ultimately are going to achieve the same goal, you need to take into account that these different communities may want different things from the project. One partner may want an equity stake. Another partner may want employment opportunities, but no ownership. Another community may want something to do with environmental impacts being remedied before they are even willing to support the project. So it's taking a step back and acknowledging what each community wants individually and understanding that what works for one community may not work for another.
Thank you, Chelsea. So Ian, I want to just bring home a point that you touched on in a few of the things you raised today already, which is, we're talking about equity participation, which means someone actually has to buy a stake in these projects, but it's not always clear, where these funds will come from. So how do First Nations finance an equity stake? And it's not just given away. As someone who advises investors and stakeholders, how do you see this business partnership advancing, and sort of what financing trends are you seeing, and how's it actually getting done?
So there's a variety of sources. Chelsea's touched on a couple that Hydro One and we're seeing in Ontario. But I'll sort of, that there's some the First Nations Finance Authority, which has been established by the under the First Nations Fiscal Management Act, offers investment options and capital planning and advice. The Canada Infrastructure Bank has established an Indigenous equity initiative, which will finance loans ranging from between $5 and $100 million, and will finance up to 90% of the equity contribution for eligible projects. So that's another source. We touched upon CDEV's Indigenous Loan Guarantee Program, which is the $10 billion program that established, which we've seen initial projects that proceed on. There are other programs as well. Ontario, we mentioned a little bit about Ontario's program. There's also one in Alberta, which has an Indigenous loan guarantee program, which was the model for the federal program. The other interesting trend is, as we see First Nations gaining wealth, and I'll credit Zach for this, but one important data point that people need to keep in mind is, and I wrote it down, like despite all the challenges, First Nations, the Indigenous economy in Canada has actually been growing significantly over the last decade. And so it's doubled from roughly $24 billion in 2011 to $50 billion in 2020. And that was during a time when we didn't have a lot of these programs. And so our hope and expectation is that these programs are going to facilitate greater private sector investment into these communities and help communities achieve the kind of wealth that we would all desire to have, and for our children, for our communities. And so the final trend I'll mention, Mo, is really about the ambition of some of these communities, which are well down this path, that are setting up, their own private capital investment arms or own sovereign wealth funds for their nation. And so those groups are coming forward and doing things like Zach's describing, setting up separate companies that'll provide the supply chain that's necessary for some of these projects to be successful, and creating new jobs and opportunities in their communities.
We've got our experts available for just a couple more minutes in our allotted time. So I'm going to open this up to Zach. We have some, potential investors in our projects, in Canadian projects in the audience. And what are some best practices they can take away with the last couple minutes we have?
Sure. I think there's three that would stick out for me. They'd apply whether you're the owner of a project or even an investor looking at a project on a diligence side. And the first one would be take time to understand and know the Indigenous parties. As an owner, it's important that if you're a proposed owner where you've got a counterparty, if the first time you're talking to nation is when you're asking them to consult, which is contentious, or asking them to negotiate your equity deal, which again, without prejudice, but it's going to be contentious potentially, and usually is. That's not where you build the relationship. And that third kind of leg of the chair is often what's most important for getting these deals through. So figuring out, if you're an owner, how to build that relationship, understanding the counterparty, it's critical. On a diligence side, same thing. If you're looking at the data room and there's no relationship, you've got an issue you should be thinking about. There's material risk there potentially. The second point would be to make sure to involve the right advisors early. For all sides, tax advisors are critical. So much of what we do is driven by tax. You do not want to get down the path far when our nation's expended money and time to deal with you. You've got this great structure you're wanting to advance, and then the tax advisors weigh in and tell you it's not efficient and needs to change. That's a terrible spot to be in. You can avoid it by calling your partners down the hall early to make sure they're involved. The third point for me is to make time to plan for the Indigenous equity steps. As Chelsea pointed out, communities have a variety of decision-making processes that you need to take into account when you have your closing agenda. Is there a BCR? Is it a First Nation that's constituted as an Indian Act band? Do you need to consider the time and process for a band council resolution? Is there a community ratification vote? Is it a Métis community where there's a community process that differs from one of those two scenarios? Is it an Inuit community where they've got a treaty that lays out the requirements for what the agreement may need to formalize in order to get you over the line? All those approval steps need to be taken into account, because if you don't, you can end up in a spot where you don't want to be with a delayed closing or no closing at all. Those would be my three kind of takeaways.
Well, I think that brings us to 1 p.m., which is our time for today. I hope everyone feels like they learned as much today as I did, because I feel like I learned a lot from the panel. So on behalf of Fasken, I'd first like to thank the Japan Society again for helping us put this talk and our audience together and bringing them together. And all of you here in our offices and listening online for taking the time to listen today. And of course, I think I speak for everyone here. I'll take this liberty when I say a very warm thank you to each of Zach, Chelsea, and Ian for your work in the sector, but also for putting your thoughts together today and sharing them with us as panel participants. Thank you. So that brings the formal portion of our session to a close, but we have about 5 minutes for questions from the audience today. And we just ask that you use a mic because there are people listening online. So there's mics on the tables or someone can bring you a mic. The green light should be on when you ask a question. Thank you.
Thank you. That was excellent. One topic which wasn't raised today, and pardon my non-expert question, but the question of hereditary versus elected leadership, how is that? When you talked about a counterparty, is it clear legally who is always the counterparty?
That's a great question, extremely important question. You've seen it come up on major projects in BC in particular, where you've got pipelines that traverse traditional territory where a First Nation, I described First Nations, may have, if you think about it, 2 layers of governance that sit, I wouldn't say on top of each other, but in some cases it's just side by side. And often the hereditary is the overlay of the elected council. Depends on who you're dealing with is the short of it. And there's a legal analysis you need to go through to figure out at law who is the proper rights holder. The proper rights holder, it comes up in Chilcotin as the leading title case on this point, and it talks about the duty to consult and what title means in the context of that scenario where you have a group who has a hereditary governance structure as well as an elected council structure. The short of it is, what do you do with it? It's an iterative process that you have to go into with a strategy, and you implement that strategy based on your legal advice. So you get to the table and you're working with the nation to understand, okay, we think the group who is the holder of the rights, the proper rights holder, and the party authorized to speak on behalf of that party is such and such. Then you're at the table asking and confirming, and it may change. At the same time, not to, put a bunch of doom and gloom, it can change over the course of a project. A nation may have a governance structure that's there, but not being expressed to you until later in the day. So you need to account for that. And we often do that in the context of our impact benefit agreements. You're thinking about getting the appropriate level of evidence in hand to be able to demonstrate that you've done that diligence, you've gone to the community, they've identified who is the proper rights holder, hereditaries if they're involved appropriately, elected council if they're involved appropriately. So you're not ending up in court with a judge trying to figure out that answer for you, which is where my sense is you don't ever want to be.
Anyone else? What? Might be a mic on your table. Turn on. See if there's a button. Turn on the green button.
Okay. Thank you for presentation and the great insights. My question is also a very non-expert question, but you guys talk about the early engagement with communities is very important during the project design. So when it comes to those engagement with the communities, who actually leads those communication with multiple communities? It sounds a very complicated task because it involves the emotion, the history of those people in the community. Also, sounds like very long journey to get the approval or consent with those communities. How, I don't know, many years or decades does it typically take to just get those engagement to start with the project?
Yeah, so I mean, I would be lying if I said it wasn't a long process. They often can take years, but it all is very project dependent. I think a part of your earlier question was knowing, like, who is going to actually have those conversations. So a lot of companies, they will have an Indigenous relations person that will sort of lead those conversations. They may already have connections in the community, so that will help at least in the initial conversation piece. But then over time, there will be more experts. So maybe the technical people will become involved, the lawyers will become involved. And then so it's really just trying to figure out where those needs are for a particular project. It is very project dependent. Like that maybe isn't the best answer, but that really is what it comes down to.
Depends on the project, I guess, but how many years? I don't know. How many years I get an impression that it takes a long journey. I don't know. Years, so.
It can be years. Yes, short answer is, one way to look at it, I think, and everything, I agree with everything Chelsea said as well, is when you look at a project, think about the regulatory timeline. And think about what that time looks like to approval and then to a commercial operation date. So that'll give you a sense of how long you have to get to yes. But if you're starting at, I want yes, start of the regulatory process, you probably haven't done enough homework yet. So you got to tack on time there. That front end engagement is so critical, and that's what often informs your level of risk and analysis to be able to say, you know what, I think we have enough time, given the regulatory process, to get where we need to be, to get the commercial deal done, to get the rights accounted for and mitigated appropriately. But it also can shift and change because under our federal and provincial environmental assessment regimes on major projects, often there's an ability for the government, the federal or provincial government, to pause the time, which can then draw out your equity negotiation or draw out your regulatory. So in that context, it's important to really, I think, keep those points.
Yeah, and I think that sort of, one of the things you might consider is the major projects office, when it got announced, they listed the first 5 projects, but they also said, you know, we've got these 6 other transformative strategies. And you know, some of them are bullets are on the list there, but you know, it's the wind power off East Coast. It's the Port of Churchill Plus, which is intended to be an energy corridor. There's a few others, but the task of the major projects office within the context of those is to set up business development teams, which will engage with First Nations, with local communities, with private sector, with the company, the banks that are going to finance it, and try to help put these together. Again, with a goal to, once that project is on the list, there's a 2-year timeline to get the regulatory approvals. Now, whether we get to a stage where that can be done on a regimented, you know, process that people are going to be comfortable with, that remains to be seen. That's a big challenge, but it's an ambitious challenge. All at the same time in addressing, you know, some of these engagement considerations. So, you know, my suggestion, engage with the major projects office on some of these business development opportunities early, and figure out, you know, whether the project you're considering is of interest, and at the same time engage with, you know, Zach and Chelsea on some of these challenges.
Ian too, should involve.
I'll come along for the ride.
Okay, thanks to the audience for the questions. That was really good engagement. I think let's leave it there because we want some meaningful time for networking for those in the office. So with that, I think we are done. Adjourned. Thanks, everyone.
Thank you.